President Trump and his family over their private lawsuit with the IRS over the leaking of Trump's tax returns years ago. The fund has been widely criticized as a slush fund to provide payouts to January 6th insurrectionists and other Trump allies, even drawing rebuke from some Senate Republicans and dividing the caucus. This is Todd Blanche, formerly President Trump's personal attorney, responding to questioning from New York Congress member Grace Meng on Tuesday.
We are not moving forward with the fund, period. The reasons for the fund is something that President Trump talked about for a long time, which is the fact that there were a lot of people in this country who had their government weaponized against them. The reasons for the fund, I think, it remain as important as they were before, but we are not moving forward with the fund.
Not moving forward ever.
Correct.
35 federal judges have just done something almost unheard of in American political history. They jointly signed a formal demand calling for an immediate criminal investigation into President Donald Trump. Not a civil review, not a procedural inquiry, a criminal investigation tied to allegations involving as much as $1.8 billion in federal program money.
A federal judge on Friday blocked the Trump administration from setting up a nearly $1.8 billion fund to compensate victims of what the president has called government weaponization. The order temporarily blocks the administration from taking any further action to set up or operate the fund while the judge hears additional legal arguments. The decision.
According to the complaint described in the file, the issue is not just one questionable payment or one controversial contract. The judges allege a systematic pattern. Federal money approved for public purposes was routed through multiple intermediary companies before ultimately flowing into entities connected to the Trump organization. What makes this case explosive is the size of the numbers and the way the money trail is described. The file refers to a 127-page complaint. Page 89 allegedly points to disaster relief funds intended for Puerto Rico, including $340 million said to have been transferred to a company called DJT Infrastructure Holdings, LLC, within just 11 days of authorization. Page 94 then describes wire transfers moving through 7 intermediary accounts before allegedly ending up connected to a Mar-a-Lago capital improvements account. If those allegations are accurate, this is no longer just a political dispute. It becomes an accusation that disaster relief money funds approved by Congress to rebuild homes, infrastructure, and communities was redirected to benefit private entities tied to the sitting president.
A federal judge today ordered Trump's name permanently removed from the building, saying, quote, and this is true, Congress gave the Kennedy Center its name and only Congress can change it. That was just the beginning of Trump's very bad day. The next shoe to drop was over his planned $1.8 billion slush fund to pay the people who helped him try to overthrow an election the last time he lost, and we should say, essentially anyone else that he wants to. The plan is now falling apart. A federal judge in Virginia put the brakes on that slush fund today, halting it as multiple lawsuits against Trump's DOJ work through their way through the courts. Remember, Trump's DOJ proposed this fund at a settlement to Trump's $10 billion lawsuit against the IRS that Donald Trump controls. And today, the federal judge in Florida, who heard the lawsuit, right, when Trump filed the lawsuit against the IRS, she said she is reopening that lawsuit to investigate grievous allegations that the settlement was, quote, premised on deception and made the court the victim of a fraud.
But the more serious part is that the case does not stop with Puerto Rico. The file claims that a similar pattern appeared in funds meant for border wall construction in Texas. According to the allegations, $680 million was appropriated for the project, with $290 million going to contractors linked to Trump. Yet only $127 million was recorded as actually spent on the wall, leaving $163 million allegedly unaccounted for. The complaint also refers to wall sections that were reported as completed, but allegedly did not exist. Invoices were supposedly signed off as showing 100% completion, while photographs and field inspections allegedly showed that the construction had never been built. That is the point where the file frames the matter not as an accounting error, but as possible intentional fraud. The key detail is an email from a Treasury official. According to the file, that official warned that the payment routing appeared irregular and requested verification of the vendor's legitimacy. But the response from an OMB director appointed by Trump was allegedly short and direct. Authorization stands, process the payment immediately. That detail makes the case far more dangerous. If an internal warning was raised and then ignored, and the money was still pushed through, prosecutors could view that as evidence of knowledge and intent. It is no longer, we didn't know. It is no longer, the system processed it automatically. It becomes a question of whether someone saw the warning and ordered the payment to move forward anyway. According to the file, a total of 6 federal programs are mentioned, including infrastructure funds, FEMA grants, border security appropriations, and Veterans Affairs construction money. The total amount allegedly affected reaches $1.8 billion. The complaint also lists 7 companies said to be part of the intermediary network, registered in Delaware and Nevada, states known for limited ownership disclosure. The companies include DJT Infrastructure Holdings, LLC, TBD Contractors Incorporated, American Border Solutions, LLC, Patriot Construction Group, Federal Projects Management Corporation, Infrastructure Development Associates, and U.S. Rebuild Partners. According to the allegations, although these companies used different addresses, they shared the same registered agent and ultimately routed money to accounts connected to Trump Organization subsidiaries. That is why the complaint is said to cite several federal criminal statutes, including wire fraud, theft from programs receiving federal funds, and RICO, a law often used in cases involving organized criminal enterprises. In other words, the judges are not simply asking whether mistakes were made. They are suggesting that the pattern could amount to an ongoing criminal enterprise. But the biggest shock is not just that 35 judges signed on. The shock is who those judges allegedly are. The file says the group includes 12 judges appointed by Republican presidents, 19 appointed by Democratic presidents, and 4 appointed by Trump himself. When judges appointed under Trump also sign a demand to investigate Trump, the story immediately moves beyond the usual claim of partisan warfare. One of the strongest points in the file is that the judges are not merely asking the DOJ to look into the matter. They are demanding an immediate criminal investigation. At the same time, they are reportedly asking the court to freeze 23 bank accounts tied to Trump-linked entities in order to prevent the money from being moved. If the court grants that request, the impact could be massive. Trump Organization-related entities could lose access to key accounts while the investigation unfolds. Operating cash flow, contractor payments, internal transfers, and major transactions could all be paused. This would no longer be a media fight or a press conference battle. It would hit directly at money, accounts, and business operations. However, the file opens up another layer of scandal, the role of the DOJ. According to Appendix J mentioned in the content, the forensic audit was not originally conducted by the judges. It was allegedly completed by the Treasury Department Inspector General 14 months earlier and sent to the DOJ in April 2025. But for 14 months, the DOJ allegedly opened no investigation, convened no grand jury, issued no subpoenas, and took no meaningful public action. If that is true, the case is no longer only about Trump allegedly diverting federal money. It could also become a case about whether the DOJ delayed or buried a sensitive criminal referral because the subject was the sitting president. When the executive branch fails to act, the judges appear to have used their constitutional authority to create a public record and force the matter into the open. The file presents this as a real-time test of America's separation of powers. The judiciary pressuring the executive branch to answer. The judges did not ask the DOJ for permission. They did not wait for the White House. They created pressure directly through a public criminal complaint. Trump's response, according to the file, made the situation even more tense. He allegedly posted on Truth Social that radical judges were trying to interfere with his presidency, that the witch hunt was continuing, and that all payments were 100% legal. But what observers reportedly noticed was that the post did not directly deny that the payments reached Trump-linked entities. It only claimed that the payments were legal. Trump's lawyers also offered a defense. They argued that all payments went through the standard federal procurement process, were properly authorized, and that related corporate structures are common in the construction industry for liability protection. That point matters because not every contract involving a politically connected company is automatically illegal. But the issue is disclosure. According to the file, the public forms allegedly listed intermediary entities such as TBD Contractors LLC, rather than clearly identifying the beneficial ownership connection to DJT Infrastructure Holdings. If that allegation is true, then this may not be a normal corporate structure. It could be an effort to conceal the true ownership behind the contracts. The part that makes the story hit hardest is the human consequence. If disaster relief money was redirected, the people who pay the price are not politicians in Washington. They are residents in Puerto Rico still waiting for reconstruction after hurricanes, border communities promised security infrastructure that was never completed, veterans' facilities left unfinished, and taxpayers who believed their money was going to help disaster victims. In other words, this is not just a financial case. It is a question of public trust. When Congress allocates billions for relief, people have to believe that money will reach the intended communities. If the money instead moves through shell companies and ends up with politically connected entities, then every future disaster raises the same question. Does relief money actually reach the victims? Or does it reach the powerful? The next few days are described as decisive. A hearing on the asset freeze request could determine whether Trump-linked entities are still allowed to move money. The DOJ's response deadline would force the department to choose, open an investigation, or explain in writing why it refuses. Congress is also reportedly preparing emergency hearings to question the Inspector General and examine the DOJ's 4-month delay. So the story has two layers. On the surface, it is 35 judges confronting Trump over an alleged $1.8 billion fraud scheme. But underneath, the deeper question is whether the DOJ buried a criminal referral because the person named in it was the sitting president. If the DOJ opens an investigation, Trump faces a serious legal crisis. If the DOJ refuses, the Justice Department could become the target of another investigation. And if the court freezes the assets, this fight will no longer be limited to social media posts or press conferences. It will strike directly at bank accounts, cash flow, and business operations connected to the named entities. That is why the file frames this as a constitutional test. Not one party against another party, not one political faction against a president, but one branch of government saying that if the agency responsible for investigating refuses to act, the system must still have a way to force the truth into the open. At this point, the biggest question is no longer whether Trump will call it a witch hunt. The question is what the DOJ will do now that 35 judges, including some appointed by Trump himself, have put their names on a public demand for a criminal investigation. If the allegations in the complaint are proven, this could become one of the largest financial and constitutional scandals ever connected to a sitting American president. If they are not proven, Trump will have the chance to frame the case as proof that the system is targeting him. But either way, one thing has changed. This story can no longer stay buried in silence. The DOJ must answer. The court must decide. Congress will have to ask questions. And the American people will have to know whether public money was used to help victims or to enrich those sitting at the very top of power.